Good evening, everyone. I, Advocate Sagar Rao, welcomes you for today's webinar on behalf of Sri Vasant Rao Patil Lawyers Training Center, supported by the Sangli Bar Association. Vasant Rao Patil Lawyers Training Center was established in the year 2019 in the honor and memory of late Advocate Vasant Rao Patil, who was a renowned criminal lawyer and ex-president of the Sangli Bar Association. The aim of the center is to reach out to young budding lawyers and seek their overall development, imparting legal knowledge, profession ethics, and legal conscience. With the spirit of achieving this end, the center has till date arranged number of lectures of renowned personalities from various faculties. And today, we are privileged to have Honorable Justice Ambadas Joshi, former judge, Bombay High Court. Sir, thank you for joining us today. It's our utmost pleasure to have you on board. Now over to you, Advocate Abhinandan Vagyani, sir. Thanking you.
Thank you. Sir, we welcome you. Uh, Justice Shri Ambadas Joshi was born on 16th December 1951 at Ambazogai, district Bid. He completed his Bachelor of Arts degree in the year 1973 and completed law degree in the year 1976 from Marathwada University. He stood first in rank in the university for the law degree. He was enrolled as an advocate on 10th of September 1976. From 1976 to 78, he initially practiced for 2 years in District and Sessions Court at Bid. He shifted to Aurangabad in the year 1978 and started his practice in labor and industrial laws. In 1982, Sir shifted his practice, started his practice in the High Court bench at Aurangabad. His Sir's area of practice was civil, election, revenue, service, and land acquisition. Sir was also a lecturer, visiting faculty at the Institute of Management, Aurangabad, as well as at Dr. Ambedkar Law College, Aurangabad. Sir used to teach labor laws, company laws, and procedural laws. Sir was also the president of Jivan Vikas Vachanalay, chairman of Devgiri People's Cooperative Bank Limited, Aurangabad. Sir was also managing committee member of the Bharatiya Shikshan Prasarak Sanstha at Ambazogai. Sir was elevated to the High Court in the year 2004, and Sir retired in the year 2013 from the High Court. Sir was later appointed as chairman at the Maharashtra Administrative Tribunal, Mumbai, in the year 2014, which esteemed office he continued till 2017 at his retirement from there. Sir likes to travel different places, also likes to explore wildlife. Sir is known for his disciplined life in profession as well as in his personal life. Sir is master and known as a master in drafting, pleading, and procedural laws. Sir was known as very upright judge in the High Court. There is much more to say about Sir, but everybody would be waiting to join him for the today's lecture. Therefore, I request Sir to deliver the lecture.
Good evening, namaskar to everybody. At the outset, I would thank the organizer, the society, that is Vasantrao Patil Institute for Training for Junior Advocates and the Bar Association Sangli, and to Abhinandan Vagyani and all other friend advocates. See, drafting of pleading is a very vast subject. As you know, during my times of education, that used to be a subject taught for complete one academic session. And this is the total length and breadth of this subject. I would definitely make an effort to summarize or highlight the important points and aspects covered in relation to drafting of claim, written statement, and application for temporary injunction. Before I go to my PowerPoint presentation, I would present before you one proverb which used to be shared during my junior days at BEAD, because BEAD was a place where Marathi and Urdu were much in practice. Though Urdu was not in practice, out of practice those days, but Urdu proverbs continued to run the field. There was a common proverb which would be comfortable for understanding for Marathi speaking as well as Hindi speaking. I'll recite it and then go ahead. It runs like this: पहले बयान करो, बाद में साबित करो. So unless you make a statement in the pleading, you are not entitled to prove the fact that you intend to prove before the court. That is the single line Guru Mantra of drafting of pleadings. Now let us go to the aspect of drafting of pleadings. I would add one more thing before I proceed. I had a debate with one of my teachers. He is no more, late Professor Advocate Jain from Latur Law College. One day he described on brevity in drafting, and then I debated him on the definition of brevity. And the aspect of brevity then became too long in view of the various things quoted in Order 6 and Order 7. There lies the true test of drafting, that you have to be laconic. That could be appropriate word, meaning thereby that you have to be apt with the meaning that you wish to communicate. At the same time, you can't be verbose, nor you are entitled to skip any important point. That is long and short. Now I will come to the formal narration as to drafting of pleading. Let us understand what pleading means in common man's language. Why I am saying common man's language? Any word used in any provision of law, any scheme of law, has to be understood from the point of view of common man's interpretation. That is the spinal cord, basic scheme of the law. So let us understand what pleading means. What plea means? What is the plea? Plea is an assertion, making a statement, making a submission in a convincing manner. The way the Oxford Dictionary describes it, as you would see in the plate now available in the PowerPoint presentation, plea is a request made in an urgent and emotional manner. That is how the word plea has been described. And pleading is the form of a verb, a different form of a verb that it has been so described. So in the formal manner of pleading, you must remember that we are not in the times of Raja, Maharaja Jahangir or somebody in past, where the pleading would be made by ringing a bell and the petitioner standing before the authority doing the justice with folded hands, representing the grievance, and either instantaneously or by summoning the people, justice would be done. In the present form of legal system, that is the Anglo-Saxon system which we have succeeded to, you have to initiate a suit by lodging a plaint. Now what the plaint is a formal statement of the case by the party. We can go to the next slide. Now what the pleading shall contain. Now it is very interesting. Order 6 Rule 2 of CPC states that is very interesting and sort of a puzzlesome situation that has been described in this. I'll read the first line of that presentation. Pleading shall contain only a concise statement of material facts on which the party relies. I would like to read this once again and give emphasis to the underlined words and tell you why. Pleading shall contain only, I'll read it again, pleading shall contain only a concise statement of material facts on which party relies. Now this terminology, couplet of words, that is material facts, is to be seen with all seriousness. I am saying this, we means I include myself, we all have not been trained to read the law in strict adherence to the manner of learning which is laid down in Ratanlal Dhiraj Lal's book. You have to understand each and every word used in the law, have an approach to the word in its right perspective. Again, right perspective means the same perspective with which a common man would read by relying upon the dictionary. Now, what is material? How is it described? See, material is a noun. However, when this word is added to the material fact, it becomes an adjective. Word material qualifies and describes the fact, the word fact. See, now the word material fact is such a combination which requires you to first judge at your level as to what are the facts material for the purpose of placing your case before the court, which entitle you to prove those facts. And unless those facts are proved, you can't succeed in the case. Therefore, going by the meaning of the word material, you will have to understand what material is. I don't take you to very thematic aspect, but it goes to the root of the word matter. What is the matter involved? Unless you understand what is the matter involved, unless you formulate what are the material facts, it will not be possible for you to decide upon it. Now, there is one more interesting thing which you must remember as to how is the fact defined in Evidence Act. How is the fact defined in Evidence Act? Because the word fact is not specifically defined in the provisions of Civil Procedure Code. And as I wanted, you should refer to that fact by referring to the term in the dictionary. See, fact as defined in the Evidence Act reads like this. Fact means and includes anything, state of things, or relation of things capable of being perceived by sense. Any material condition of which any person is conscious is a fact. Now see the interesting part. On one hand, law requires you not to plead evidence and restrict yourself to material fact. At the same time, the very fact as defined in the Evidence Act means anything, the state of things, relation of things which are capable of being perceived by senses. And any material, any mental condition of which any person is conscious. Now, if these two definitions are read together, then I have not included in the PowerPoint presentation, but I would take you to Order 14 of CPC also, where you have to have the issues involved in the case. And once you refer to the issues, it again takes you back to statement of material facts required to be pleaded in the plaint. And I'll take you to the next point. I'll take you to the first point once again. You have to plead material facts and not evidence. That is the rule. So you have to distinguish between material facts and evidence. I'll give you an illustration which is not included in the PowerPoint presentation, the explanation that I am now going to give you. While discussing the provisions of law or interpretation of statutes, I have been presenting it before the students and my colleague lawyers that when you put a question in relation to law as to what is the provision of law, you refer to the text of law. When you put a question why, it refers to the jurisprudential aspect, the philosophy and principles behind it. And when you put a question how, it refers to the procedural law. Now, when it comes to pleading of facts, same set of three interrogatory question words I wish to use. When you put a word what, it is a fact. When you put a word when, it becomes evidence. When you say how, it could either be a fact or it could be evidence. So by putting all these questions to the set of facts, you have to segregate the facts from evidence. For an example, we put it this way, that there is a suit on contract in relation to transfer of immovable property. In old times, before 50 years, 100 years, the pleading used to be that there is a contract between the plaintiff and defendant, where the defendant agreed to sell ABCD property to the plaintiff. Earnest money was paid, remaining money was offered. The defendant has refused to perform his part in spite of notice and therefore a suit. The suits used to be so brief. Before I conclude, I'll also emphasize as to the why the brevity has now been undermined in the changing time. I'll deal with this aspect later. But right now, I am only describing it to you as to what is the material fact. Whether agreement was entered on a particular date becomes a material fact because it will determine the limitation. Whether earnest money was paid becomes a material fact because it will decide as to whether balance consideration was offered. When the consideration was offered, offer becomes a part of performance of promise by the plaintiff or application for performance of promise, and therefore it becomes a material fact. This is how you have to deduct from the entire set of facts by sorting out what constitutes material fact and what is evidence. Now, there are certain elementary rules which have to be understood as a rule of common sense, but need to be stated and told very specifically. See, Order 6, Rule 2, Sub-Rule 2, what does it say? It's in fact common sense, but unfortunately it is required to be brought into law. And there is history behind it. See what it is. Pleading shall, when necessary, be divided into paragraphs. I'll read the same in continuation. Pleading shall, when necessary, be divided into paragraphs, numbered consecutively, each allegation being, so far as it is convenient, contained in separate facts. I'll mention one small thing, interesting fact here. I have seen some lawyers consciously and deliberately mixing various facts. At times, it is considered to be shrewd way of drafting. But I have always been believing in very sincere and honest way of being a professional as a lawyer. Therefore, being strategic, being shrewd is fine. But you must remember that if you lay down mines on the road, I believe you know the mines. The army people lay the mines on the road to entangle the enemy. If you plant mines on the road, it is very much likely that you too could be a victim of mines. Therefore, it is always better to be very candid and honest and ensure that all facts are stated in strict sequence. I'll tell you one more objective. See I don't call it pitiable, I call it tedious. See the tedious job of a judge. He has to read the pleading and draw the issues in frame the issues to be tried in the case. If the pleadings are not arranged in proper sequence and proper paragraphs, the reply is going to be clumsy, and then the framing of issues is going to be complicated. If proper issues are not framed, a man in possession would always like to connive at and say that at the stage of appeal, I shall raise a question that proper issues are not framed and I did not get a fair trial. But then this is no justice. If you really want proper justice to be done, and if you believe destiny of the litigant, you should be candid enough to see to it that the pleadings are properly placed in sequence and are properly divided into paragraphs. If the pleadings are properly divided into paragraphs, it helps the respondent to answer them in a very categoric term. This is a rule of convenience for the respondent or defendant, but this is a rule of benefit for the plaintiff and convenience for the judge. While being selfish in the matter, you should always see to it that convenience for the judge is always a matter of gain which a party and the lawyer gets. There is always a credit, as it is said in a humorous way, that at the end of the paper, you always get 5 marks in the mind of the judge for writing very clearly, candidly, in a beautiful handwriting, not making it clumsy. That is how you earn the goodwill while drawing the plaint in a very perfect manner, arranging the sequence of facts, arranging them and dividing them in paragraphs. One more thing I want to add at this stage, which I have enjoyed as a lawyer and suffered as a judge. It is this: whenever you as a lawyer arrange the sequence of facts in such fashion that facts which are undisputable means other side is not likely to dispute. Remotely, one may dispute any damn thing. But normally, if it is a suit for partition, A and B are sons of defendant number one. If you write like this, unless the paternity is to be challenged, there is no possibility that this paragraph or this point would be challenged. As a matter of convenience, if you arrange the sequence of pleadings in such way that facts which are not likely to be disputed in ordinary course are segregated and put into independent paragraphs, what is the consequence? You get a reply. Contents of paragraph number 1, 2, and 3 of the plaint are admitted. If the pleading is of such nature that there is a possibility of those being disputed or being clarified, you devote a separate paragraph for that. Thereby, you get a reply with a very clear and distinct assertion that this paragraph is denied, disputed, not admitted, or reality is in this way. If you segregate the facts and say that the notice, say for example, notice is issued to the defendant. Instead, you say that notice is served. And in fact, you want to plead that notice is deemed to be served. What shall be right way of pleading? Plaintiff sent a notice by registered post with acknowledgement number so and so. Document is annexed at list number so and so. Notice was, postman's report says that notice was tendered. It was sent on the usual address of the plaintiff or on the defendant on which previous correspondence was delivered. And as per the belief of plaintiff, defendant continues to stay on the same address. In spite of repeated efforts, notice has not been served and therefore it is deemed to be served. If you have a pleading of notice in this fashion, you would get an expected reply. I am not saying a favorable reply, an expected reply, because you know what other side is going to plead. Therefore, proper paragraphing is a most inevitable thing to be done in the pleading, which unfortunately is seen not done. I have come across numerous pleadings and petitions where paragraphs are not very sincerely done. See, mostly what happens, the senior advocate tells the junior to draft, puts a couple of cross questions, whether you have done this way, that way, is it properly pleaded, and then the plaintiff is accepted for filing. And then when it comes for trial, the senior is at a puzzle to search out the pleadings. This situation should never occur in the life of a lawyer, and this prevention is possible by adhering to the strict division of paragraphs. Another very simple rule, and I say unfortunately, because see what happens, if you have read history, I am taking you to some other field. If you have read history, if you have read old type of old document, I'll illustrate to you. A plaintiff, see, it is like this. I'll illustrate in Marathi, English both. That A property is given to B. X property is given to ABCD. The property is numbered as survey number so and so. It consists of so and so acres of land, meaning thereby it is so many guntas. Multiple descriptions of the same thing used to be done in an earlier fashion. I want to give to my brother 20,000 rupees, meaning thereby 10,000 plus 10,000, 5,000 plus 5,000 plus 5,000 plus 5,000. This used to be the precaution those used to be taken in the old days, where drafting of pleading was not formally, or drafting of deeds was not formally taught to the people. People with normal routine experience of life. Attempt and effort is to ensure and guarantee no ambiguity. Therefore, whenever you write a survey number, to eliminate a human error, to eliminate an error in scribing, to eliminate an error in copying, you should always say, I claim a decree for a sum of rupees 20,000 TWENTYTHOUSAND only. Because I have come across a suit, it's really humorous to listen to this story. I came across a suit, I was a bank's lawyer, and then other side came with a plea that see the court has granted only 0.5% interest. Why did it happen? Because those days there were no stenographers, direct dictation was given. The typist was a trusted man. So learned advocate dictated it should be decreed with interest at the rate of 12.5%. 12 was swallowed by the typist. He typed only 0.5%. Had it been a case that 12.5 into bracket TWELVE and HALF, probably the mistake would not have happened. A very small thing, but a very serious thing. Therefore, when it comes to describing the figures or narrating the figures, you must write the figures in which are either dates or money or description of property in double format, that is digital, that is figures as well as words. Next slide. This is very simple and very interesting. See what happens. I must mention one small thing at this stage. Whenever you sit down for studying the drafting of pleadings, it is never sufficient to study barely the chapters of drafting of pleadings. At every point of time, you have to refer to various other laws. For example, that is Order 6, Rule 4. I'll read the plate and then go on explaining intermittently. If a party relies on misrepresentation, fraud, breach of trust, willful default, or undue influence, in all such cases, in which particulars may be necessary beyond those mentioned in the forms Appendix A, must be mentioned. See what happens. Where is the fraud defined? That is under fraud is defined under Indian Contract Act. Undue influence, all that is defined under Indian Contract Act. Whenever you come across filing of a suit in relation to such matters, you have to go to that law and find out what are the ingredients. And once you understand the ingredients, pleading of such ingredients becomes inevitable, being a material fact. If you are a minor and if you want to plead that the contract is not binding on you, you have to plead that I was minor at material time. If you are pleading undue influence, you have to plead not only that the consent was vitiated due to undue influence, but also that the plaintiff was in a position of being influenced and that the defendant was in a position of exerting the influence. These are the niceties which help you to go for the details of drafting of pleadings. Excuse me. आवाज वाढवायचा का? Yes, I'll go ahead. Whenever you are pleading conditions of precedent, it is necessary to plead what is the condition of precedent in the contract. I'll give a collateral example. Take a case of sale of goods. As you know, because very few lawyers get in their life a chance to deal with a case on condition and warranty. Therefore, I am giving that illustration. Take a case where there is an implied condition of quality and fitness. And if it is not pleaded, how do you get an issue framed? And how do you get the reply of other side? Therefore, pleading of such conditions precedent, which are essential of the contract and going to be the foundation of decree to be received in that matter, done in your favor, you must plead all such necessary conditions. Another rule you must know, that is no further pleading, or there shall be no further pleading. However, you have to keep it in mind that Order 6 Rule 17 provides for amendment, and anything that is not stated in the plain, if you wish to be added, can be added only by way of amendment and not otherwise. Therefore, see how the funny picture comes out. You are not supposed to plead evidence. You are supposed to plead material facts. You are not entitled to plead anything which is not contained in the plain. This is how you have been provided with a canvas, brush and paint and told to draw a picture. That eyes must be seen, ears must be seen. You know, how do you have a photograph for a passport? Your eyes have to be there, forehead has to be there, both ears have to be visible, This is how plaint is a passport type photograph, where every organ has to be visible, which is necessary for identification. Next. Now, general rules about denial. This is about written statement, but order 6 pertains to the as a rules, general rules of pleading. Therefore, you will find many things are contained in the order 6 as well as order 7. Similarly, in relation to written statement, many things are contained in order 6 as well as order 8. Therefore, there may be some overlapping and repetition, but this has to be done because I have chosen to pass up going with reference to the orders. See, what is the common rule of written statement? Written statement, we have to go to the basic principle of present system of trial. Unless you understand it, your written statement is not likely to be proper and perfect. What is the system that is commonly understood? Present system, what is it known? It is a system known as adversarial system. We all involved in the system of doing justice with the present mechanism are all human beings. We strive to secure justice, plenty for defendant and judge doing justice with human limitations with the adversarial system, meaning thereby that a party comes with a plea, the plaint as we understand, an application as the case may be. Notice is sent to the respondent because principles of natural justice have to be followed. There can be government justice. However, in case of government justice also, I must mention at the cost of little departure, the story given in relation to the emergence or birth of principles of natural justice is of Eve and Adam, where Adam had plucked an apple from the garden of the God, of the Lord. And when Lord wanted to punish him, he did not just straight away punish him. God is almighty, he could understand anything what has happened all over. But he called Adam to show cause as to why he should not be punished. This is how the basic concept of hearing and adversarial system comes up. So whenever somebody prays for a decree, the other side who is under law bound to answer the plaint is called with a notice. Notice accompanies the plaint. If not accompanied, lot of provisions are made in order 8 as to how it is to be brought to the notice. If it is incomplete, what provision, and many things like that. I'll come to basic principle of adversarial system. He is called to say something. What is it? What the notice says? You may see the format of summons for that purpose. In case of small cause suit, it's a suit summons for judgment. In regular civil suit or special suits, it's a suit for settlement of issues, in which a statement is contained that you are called to file your reply. And effect of not filing of written statement are given at various places in civil procedure code, which I am now going to deal with. Say, for example, order 6 rule 10, order 8 rule 10, order 12, and few such provisions, where the party receives the notice but remains ex parte, meaning thereby does not turn up. Another example, turns up but does not file written statement. Files a written statement but is casual. Now, what is this being casual? You have to understand what is contrary to being casual. Contrary to being casual is being serious. How are you serious about the plaint? You become serious about the plaint by reading each and every statement of fact contained in the plaint. What is your response as a defendant? Plaintiff gives his description, age minor. For example, you are in fact called upon to respond to the status of the plaintiff. It could be that the plaintiff is concealing his age and pretending to be minor and wants to have some other game at a later point of time. Claims to be insane. Therefore, as a lawyer, as a judge, I may not comment on this, but as a lawyer, I would say that you have to read each and every line right from the title of the plaint. In the court of so and so. First question, whether the suit is instituted in the right court. If not, your plaint would open with saying that I have a preliminary objection to the plaint as to the jurisdiction of the court on account of territorial, pecuniary, or whatever way you could. Then it would come to description of defendant. If proper parties are added or not, you have at a right place in the plaint to say that parties are not proper. In partition suit of an undivided Hindu family property, all sharers are not added as a defendant, as defendant. The suit becomes defective. There can't be fair, equitable, and reasonable partition. What is the result? Result is that there can't be adjudication. The adversarial system itself comes into shadow. Therefore, while reading the plaint, the job of the defendant begins of vigil at every stage. Then comes the description of the claim in the suit. You have to, at right time, appropriate stage in the plaint, dispute, deny, clarify, whatever way you have to say about the plaint. Valuation, because plaintiff has to narrate the valuation in the beginning and at the end. So there is an opportunity for you to test the aspect of valuation in the plaint. Then comes the status of plaintiff. Take a case where there is a suit filed as guardian of a person who is minor or under care for whatever reason, insaneness, mental sickness, or something like that. And you need to admit or deny his status as a person of unsound mind. See, for an example, somebody is a man of sound mind and does not file a suit within limitation. And late after 5-10 years, somebody comes as his guardian caretaker and wants to file a suit. The status or date of the person having become a person of unsound mind becomes crucial and relevant. So when in the first paragraph of the plaint, it is stated that plaintiff is represented by his next friend, comma, the plaintiff being a person of unsound mind. Here you do not have simply to say denied or admitted, but to say that the fact of unsound mind is not admitted. The denial has to be absolutely categorical. Absolutely categorical. Evasive denial is considered as admission by virtue of case law. So there is no excuse from categorical denial. I have seen many lawyers drafting in a very shrewd manner, not admitted, or a plain simple paragraph denied. It's okay. But if the defendant has a story to place, he would not be entitled to place his story in absence of a proper denial being pleaded. Bare denial shall not be considered as a denial when it comes to contract. Say, for example, there is a contract between A and B to sell a gun, and A possesses a gun but does not have a license to possess it, and B denies the contract. But later on, it turns out that A possesses a license, or issue has gone blank, and at later point of time you deny the legality of the competence to sell. Therefore, when it comes to competence of a contract or legality of contract, legality as well must be distinctly denied. I'll skip other plates because as I mentioned that I would take about 25 minutes on the plate. Sorry, on the returns. Anyway, there is some time. I'll go ahead with that. Now, one point I'll mention about clumsy plates, how to deal with at the time of denial. Because I have mentioned while narrating that a prudent, a candid lawyer would always divide his plaint in proper paragraphs. But how to deal with a situation where with deliberate effort, shrewdness, or out of dishonesty, certain facts have been mixed up. Facts which have to be admitted and which have to be denied are consciously mixed up in one sentence. I have come across many such plaints. In such eventuality, it is always advisable, rather strongly recommended, rather insisted as far as I am concerned, that facts admitted and facts disputed should be distinctly pleaded in the written statement. And I think this point is clear to the audience. If not, I would welcome any question on this in the question over session of the later part of it. Now, there is one interesting thing which is common to plaint and written statement. Okay, I'll go to the formats of pleading. See, in Civil Procedure Code, you will get the annexure, that is a schedule, where various types of claims have been listed and various formats have been given. These formats help you as a guide in order to ensure that these are the points on which you must plead. It is like a cloth provided to you where embroidery is to be done by you, by your skill. Now coming to the other imperative parts of the plaint, it is already touched by me, but still I will mention that parties have to be properly described. Now what is proper parties? A person has got two first names, Babu Rao alias Ram Rao, for example. So whenever some such thing exists, as far as plaintiff is concerned or defendant is concerned, you must ensure that the proper description of the parties is given. It's very common in villages as well as in urban areas that you will find number of persons with the same name, first name, number of persons with same name and same father's name together, number of persons with same name, same father's name and same surname. There could be persons of same name, age and many other descriptions. Therefore, giving most apt and appropriate description of the plaintiff, full and proper address of the plaintiff is essential, imperative. What is the effect? See, plaintiff's suit is decreed and defendant files an appeal. And in the meantime, plaintiff has changed the address or address is incomplete. I have seen in few courts, I must mention it, that the plaintiff's name is given through some association, care of some association or care of lawyer, which is absolutely wrong, should never be done. Therefore, a proper traceable address, a proper description of the party. In old days, I am telling this 150 years old story, those days there was a practice of writing caste also. Now it is not appreciated, nor it should be done. But I am just mentioning as an illustration, because those days surnames were not common. Caste is to be common. So that was the way of identity. Therefore, now surname, alternate name, additional name, age, sex. Because see what happens? There are some names which are names in male as well as female. Yes. And there is a confusion as to identity. So full narration of the party is necessary for identity. Next is, if it is a partnership and all partners are not added in the party, because I have come across a case where in the stage of a decree, the party started complaining before the court that, my lord, the court has given a decree, but I am not able to execute because all partners' names have not been included. Who is at fault? It's the plaintiff. Because partnership is not like a body corporate. Partnership is always represented through partners. Therefore, names of the partners are on the board necessary. If it is a joint Hindu family, Karta is necessary, all other members are necessary. So whenever it comes to individual or any other identity of the party, proper and fullest description of the parties is imperative. Next is as to the property. Yes. Yes. Now there are certain mandatory declarations to be made, which by habit you people do. If you do not do it, your registrar of court comes in your way. But before he raises an objection, it is imperative for you, and therefore you must remember it. Is certain mandatory things which are required to be declared and stated in the plaint. Those are about valuation, valuation for jurisdiction, valuation for payment of court fees, then territorial jurisdiction, then subject jurisdiction, then limitation for suits, whether it is in limitation. If you are claiming exclusion of limitation, you claim that the limitation has stopped running for good reasons. A proper pleading in that regard is required, because in the matters of limitation, courts have to be very, very rigid, and therefore proper pleading is necessary. The person who files the plaint, unless he is an individual in filing own capacity and otherwise competent to file, a proper description is necessary. In case of minor, guardianship, natural guardianship, legal guardianship. Next point, no adverse interest. Person of unsound mind, Next friend, status as a next friend, permission to sue in representative capacity if you are in representative capacity. Therefore, the party's authorization and competence in law to file a suit must be eloquently and adequately described. If he is a power of attorney, the nature of power of attorney, its cognizability in the sense that it is notarized, it is registered, must be pleaded in order that no further and future questions are admitted. And if you are enjoying benefit of some presumptions, those could be validly taken. Now, another interesting thing is about prayers. See, lot many things can be said about the prayers, but I'll give one ancient example. One man was making prayers to the God. How are the prayers made to the God? You chant some stotra or some puja, something like this. So he was chanting a stotra. It contained words meaning thereby that Rakshiti Mama Bharya, save my wife, save my wealth, save my reputation, save my property, or something like that. But while uttering, instead of Rakshiti, he used to say Bhakshiti. So what is the consequence? His wife died. He married again, second wife died. Third wife, she also died. Then he went to his guru and asked him, sir, what is happening? What is wrong with me? After examining everything, he asked him, what do you chant? Please let me know. What are you praying to the God? He chanted it. And then he said, you are praying the God to eat your wife, not to save her. This is how the fun is. I have mentioned to you what happened if the typewriting mistake occurred in relation to interest. If a survey number is mistaken, what happens? You get a decree for which there is no property in existence. Therefore, when it comes to prayers, you have to make it sure that whatever is the description contained in the plaint, insofar as the description of property is concerned, must be meticulously and minutely, fully narrated in the plaint. When you are claiming perpetual injunction in relation to protection of possession of certain property, it is necessary to describe it to its fullest extent and pray that the defendants be, by an order or writ of injunction, restrained from entering into peaceful possession of the plaintiff's enjoyment and possession of the suit property, specially demarcated and narrated in paragraph number so and so, and map annexed to the plaint. So, eloquent prayers is absolutely imperative. No choice, never be miser in making adequate prayers. There is always one small word of caution. Make distinct prayers. If each prayer attracts independent payment of valuation and court fee, does not matter. You are never supposed to save on court fees and valuation. But make each prayer distinct. It helps you deciding what you got and what you did not. Because I have come across a humor quoted by one of the judges one time in lecture, that after getting a decree, the plaintiff goes to lawyer to find out whether he has succeeded in the suit. Many times there is a practice in courts that suit decreed in terms of prayer clause A. And what is prayer clause A? I have seen many judges in the High Court also, those would never stop saying allowed in terms of prayer clause A, they would quote which reads as follows. As you know, there is a practice of a form of decree to be supplied. Why it is so? Because there has to be no ambiguity. If the judge has said suit is decreed, the decree has to be in terms of the prayer and not otherwise. The judge passing a judgment or drawing a decree can never exceed the limitations of the decree. That is the reason, limitations of the prayers. This was settled way back in 1898. I have put a citation, oldest citation for this purpose, that the judge cannot grant a decree beyond the prayers. What is the reason? Very simple. We have understood the doctrine of adversarial system. If the defendant does not know the prayer for which the suit is filed, he would say, all right, I will not come and file a written statement. Why should I spend on a lawyer? Why should I spend my energy to coming to the court? There is no prayer against me. So ultimately the prayer is a thing which he has to oppose. He has to fight, he has to deny the pleading, but what he opposes is the prayer. So adversarial system is not complete without due, adequate, proper and eloquent prayers. Any ambiguity in the prayer is a fatal attack on the client, a fatal defect in the plaint, and a serious lacunae attached to the ability of the lawyer. So never miss it. Now another interesting thing which I want to tell is about the format of verification. Pardon me for being very harsh on this point. I have not come across lot or large number of lawyers who could be identified for worthy verification. I quite understand that my observation, my last sentence could not be easily understood, so I wish to repeat it. In my 28 years or plus standing off as a lawyer and around 15 years as a judge, I have come across very counted few lawyers whose number could not increase more than the 10 fingers of the hand, who could properly fill in or properly draft a verification statement at the foot of the plate. What is verification? Let us go to the dictionary meaning of the word verification. It is not given in my PowerPoint presentation, but let everybody do it after going home or after my lecture is over. What is verified? What is veracity? It is analysis of the truth, the fact, and the matters which are apart from facts, absolutely within the knowledge of the party signing that he verifies it. Those who have some reference, some knowledge about accounts know what is stock verification, what is verification of goods. You have to go and find out physically whether the particular thing mentioned in the book of account is found in the stock in the godown, whether it is very well there in the cupboard. This verification statement at the foot of plate is a verification, a stock statement of variety of statements made in the plate. What is the effect? Why it is required? It's a ritual. You know how casually it is done. A very good lawyer also dictates or writes the plate and lets his stenographer or junior to fill in the verification statement. Why? It is because the seriousness of the verification statement is not understood. What is the format of verification? The first and very interesting thing is it is a statement on solemn affirmation or oath. I would suggest Mr. Vagyani and your team to have an independent lecture on solemn affirmation and oath. Let anybody come. No issue, that not that I have to do it. Because there is a gravity is lost. What is solemn affirmation? You as a learned lawyer, why lawyers are called learned? Because they really go to the subject in depth. In old times, Vayyakarani, those who are masters of grammar and language used to be lawyers. It is the wit and learnedness in the life that matters for your being a lawyer. What is the solemnity and what is the oath? You need to study it philosophically. A man who believes in solemnity of life, that he would never lie, he would never lie in the life, makes a solemn statement for verification. Verification is made with all solemnity. All his wit, wisdom, integrity, morality is put into task. And there he makes a statement that I do solemnly state and affirm and state as follows. Those who believe in some other form, God in some other form, that they shall be truthful after taking an oath, have to verify our oath. That, what is that? Certain paragraphs contained in the plate and are true and correct to the best of my knowledge. Now each word is important here. Paragraph numbers 1 and 2. Now you understand the importance of pleading being divided into paragraphs. Because after dividing the pleading into paragraphs, you have to write at the bottom of plate that paragraph number 1 to 6 are based on my personal knowledge. What is knowledge? You have to go to dictionary. What you saw in your dream in the night is no knowledge. You had a dream is a knowledge. But what you saw in the dream is not a knowledge. What is knowledge? When you have perceived something as is defined in Evidence Act, things perceivable by senses, you have perceived a thing as to its physical existence or other way of perception is knowledge. A said something to B and I have heard it is a knowledge of the fact that A said something to B. If you have pleaded it in this fashion, it's a personal knowledge. But if you put that knowledge as a bare pleading, it's not a personal knowledge. Therefore, you have to analyze the facts which are of personal knowledge and put them into divided paragraph. Now, second is you write something on the basis of information received. See what happens. What is stated on the information received is hearsay and it does not have evidentiary value. But it is a relevant fact as far as Evidence Act is concerned, which entitles you to bring evidence before the court. Therefore, the verification statement is a locus as we understand in mathematics or coordinate geometry, as a locus of a point. The point proceeds in a particular fashion. So here is a case where your statement of verification based on the analysis of facts contained in the plate creates for you a path of leading you to the witness box, either for yourself or for your witness box. Another interesting thing which I want to mention, because this is really not taught either in the college or rarely by seniors and in the court also, therefore I am mentioning. It is for my own satisfaction that I have been saying, and I have also shared it with the lawyers who appeared before me, that listen, this is very important for lawyers. Quality of verification statement and the signature of a lawyer somewhere nearby decide the worthiness of the lawyer. Because your client never drafts the plaint. Client comes with a bundle of facts. You draft the plaint. Therefore, whenever you draft the plaint, whenever you draft the written statement, it is your credibility that comes. And your client earns the benefits of your credibility. Therefore, verification statement is a very, very serious matter. And the last point as to why. Decree of suit when no denial. Okay. I'll mention 2 points or 3 points and skip on that basis. See Order 8, Rule 10 of CPC. What is that? Party appears but does not file a written statement. Court can decree the suit at the outset. Why? Because there is no denial. There is no reply at all. In Order 8 also there is a provision. This was Order 8, Rule 10. In 6 also there is a provision that when there is a no denial, it is possible for the court to at the outset decree the suit. And whenever there is admission, there can be a judgment on admission also. If there is an evasive admission, evasive denial, it could be treated as admission. Therefore, the properly verified statement leads the judge to draw a conclusion as to due weightage to the statements contained in the plaint. And therefore, verification seriously done is very important. See what happens? Naturally, the lawyers make the judges, good lawyers make the good judges. So if a good lawyer has a habit of drafting a good plaint and a good verification, and then he becomes a judge, he's bound to be a good judge because he knows what to find where. Next. Now I will mention, but not go deeply. There is a cross check. As we understand, there is a cross check in arithmetics or mathematics. So there is a cross check in the drafting of plaint. As far as Order 7 is concerned, if you refer to Order 7 to Order 7, Rule 1 to Rule 11, you get a negative points. That if this is not written, what shall happen? When the plaint shall be rejected, when the pleading shall be struck off. These are the cautions to be taken care of at the time of drafting of the plaint. And therefore, you must once concentrate on Order 7, Rule 11 to find out as to what is an imperative part in the judge plaint. Yeah. So, we'll jump. Yes. I'll mention few more points about written statement and then go to application for temporary injunction. The PowerPoint presentation consists of 136 slides, and I recommend that those are already displayed and those could be seen. If not, those who send me their email or I'll send it to your association. About written statement while dealing with Order 6, I have already mentioned. Therefore, the plate which is now appearing on the screen tells as to how the denial should be done. Next. I had referred to Order 6 without mentioning the rule. This is that order. Order 6, Rule 5A. That court can inquire into the fact which has a power to direct the facts to be proved or admitted, because there is always allowance for defective pleading, and the judge has to do justice, not technically, but substantially. Then Order 8, Rule 20 is the pronouncing judgment. Now, one more thing that I have already mentioned, that plaintiff could independently tell what defendant could also tell what his story is. So, in addition to the denial that defendants are required to say, that is, they are denied certain facts or facts are incorrect as stated in the plaint, they have a duty to tell their own story. I'll tell you the reason why it is. You may recollect Section 106 of Evidence Act. It refers to the burden of proving the facts exclusively within the knowledge of a particular party. If defendant wants to plead some specific plea, its foundation is to be laid. And therefore, the certain facts which are within the personal knowledge of the defendant and he wants the facts to be proved, such facts which as a correct fact must be stated in the reply. Now there is a counterclaim and set-off. I will only narrate certain things briefly and proceed. See, transaction is admitted and the plaintiff defendant claims that I have something more to receive in adjustment. Now I have a set off against the money that I have to pay to the plaintiff. That must be set off. If plaintiff defendant wants to say that had the plaintiff not filed the suit, I would have myself filed a suit, and it could be set in the form of a counterclaim. Only restriction is the valuation of the counterclaim should not exceed the jurisdiction of the court. And what is the effect? Had you filed an independent suit, it would have been tried together. If you file an independent suit in a higher court, court of higher jurisdiction, and the issues are concurrent, the suit could be stayed or could be clubbed and could be heard together. Therefore, for all purposes, counterclaim is a suit. All rules which apply to the plaint apply to counterclaim. All rules which apply to written statement will apply to the written statement to be filed to the counterclaim, including time limit, including Order 8 Rule 10 of CPC. Now I'll go to the temporary injunctions. Friends, what is normally discussed but rarely taught either in the college as well as during long juniorship that I want to share. Those seniors who have taught this will pardon me, they deserve recognition and reward. Whenever in a suit application for temporary injunction is being made or being heard, an appeal is being heard, I have not come across, except counted few lawyers who have either argued or asked their juniors to study specific Release Act. The very concept of injunction is based on principles of equity. Principles of equity as enforced in the Court of Chancery in England. Principles of equity as were enforced in India by virtue of the conventional law or as mentioned in the latest patent. You must for academic purpose read latest patent because it specifically contains narration that the court shall continue to enforce the law and equity as in existence in past. So rules of equity were unwritten based on the case law, based on principles of jurisprudence. In India, since the legislative principles came well in advance, because Contract Act was unwritten, law of contract was unwritten in England while it was written law in England. So Specific Relief Act also is one such act where principles of equity have to be followed, however, within the parameters as laid down in that. Section 36 and Section 37 of the Specific Relief Act refer to the injunctions to be granted. Subsection 1 of Section 37 refers to the temporary injunctions which are to be granted for preventing the breach as contemplated by Section 36. Section 41 of Specific Relief Act refers to the principles when injunction is to be refused. Now, these are the principles which you have to understand. While drafting of the application for injunction, please keep it in mind that why you are filing an application for injunction in order to prevent the prayer made in the plaint in main suit being prevented for frustration or the recurrence of the breach which would occur during pendency of suit or even after decree of suit till the decree is executed could be stopped or prevented. The status quo as it existed on the date of suit should be preserved, conserved. A situation as contemplated by Section 144 of CPC of restituting the situation should not occur because all this results in multiplicity of proceedings. For securing the ends of justice, it is necessary to protect the plaintiff who has knocked the doors of justice. What is the use if a party is asked to wait till the end of decree and then do the exercise of reversing the whole thing? Therefore, conserving the cause of justice, ends of justice, protecting the plaintiff from recurrent breach is necessary. This recurrent breach could be in relation to tortious act, in relation to contractual liability, in relation to protecting the devices, protecting the execution of decree. For example, some person is having a money suit and the party is likely to dispose of the property and flee away from the jurisdiction of the court. How do you execute the decree? You will execute it. You will run behind him from jurisdiction to jurisdiction. Law provides for giving a precipice, transferring the decree for execution. But is it the object? No. Therefore, it could be done that the party is prevented from destroying or defeat the decree. Therefore, all these preventive measures could be taken by taking recourse to Section 94 of CPC based on Section 36, 37 and Section 41 of Specific Relief Act. Insofar as Order 39, Rule 1 and 2 are concerned, it does not prescribe the manner and form of application for filing an application for temporary injunction. But it, however, lays down the circumstances in which the court would exercise the jurisdiction. This provides you the path and leads you as to how should you draft. At times there is a practice of writing that for the facts stated in the plaint, or at times for the facts which are practically copied from the plaint, the injunction is sought. This lets you to the facts, lets you to a proper pleading of foundation of facts as far as the application is concerned. What are the grounds for granting injunction? Foundation for claim is stated in the plaint, but granting injunction is the breach that you want to prevent. Recurrence breach of your right that you want to prevent. The acts of the defendant which would result in defeating the decree that you want to prevent. The sale of property that is likely to occur which you are going to prevent. multiplicity of litigation that you are likely to prevent by application for injunction. These are the grounds on which you are entitled. You have to look upon the facts, upon the points stated in section 41 of Specific Relief Act, where the injunction would be refused, are the cautions which you have to ensure that those are taken care while drafting the plaint, drafting the application for injunction. Normally, if you go to the very first rule of Order 39, Rule 1, that is indicator of what should be pleaded. 39. See, I'll read the initial part. Where in any suit it is proved by affidavit or otherwise. Now, what is this? This is a Pandora's box. What is this affidavit or otherwise? I'll tell you the reason. When you approach the court for temporary injunction, what is the material before the court? Plaint, documents along with the plaint. Those are so far not proved. So what is the material? Why should court believe that whatever plaintiff is stating is true? Therefore, proper pleading of facts as stated in the plaint to be summarized in the application for temporary injunction. Secondly, the grounds on which you are invoking the power of the court. Court has power. You have to invoke it. You have to appeal to the mind of the judge to take recourse to the powers which the court has and exercise its jurisdiction, thereby restraining the defendant from doing a particular act. Why it should be done? Because the breach is so recurrent. Take a case of easement by necessity. You have to go to the main road by approaching from the particular lane, and he creates obstructions every day. Will you not state in the application for temporary injunction that my suit is based on easement of necessity, my suit is based on easement of prescription, my way is established, my way is being obstructed, this obstruction results in gravest inconvenience or results in wrongful confinement, whatever you want to plead. Thereby, you invoke the mind of the judge, equity in the mind of the judge, and convince him for granting injunction in your favor. An affidavit at this stage is necessary to enable the judge to form an opinion. Now, why affidavit? Statements have to be contained in the application for affidavit, which lead to demonstrating or establishing the recurrent breach of right. So what is required? Pleading of right. Facts is necessary for that purpose. Then recurrent breach or the circumstances which are going to defeat the ultimate decree that you are praying for. It be either preventing dispossession, preventing wastage, preventing spoiling or damage, preventing recurrent breach of trust, preventing property being alienated, preventing goods being transferred beyond jurisdiction, or whatever that could be the fact of the matter. Therefore, all such pleadings are necessary for the purpose of filing an application for temporary injunction. Now, what is the reply? All that is stated is not correct. You will have to plead how the plaintiff's apprehensions and fears are wrong. Without that, you can't oppose it. The principles apply to written statement would broadly apply to the reply to the application for temporary injunction. Therefore, never be miser. One interesting thing I want to share at this time for filing reply to written statement. There are plurality of opinions on this point. I have seen many lawyers who prefer to file reply to temporary injunction initially, and see another interesting thing. At later point of time, they adapt the reply to application for temporary injunction as reply to plaint. I do not recommend filing a short reply or filing a detailed reply and then saying that I adapted. I would recommend filing of a reply to the plaint as well as a separate reply to filing of application for temporary injunction. This leaves no ambiguity to the judge. This creates your image of fairness and candidness before the court. Unless it is a case where certain documents are not available, you genuinely need time to file written statement, you are free to do it. In that event, you should cautiously reply the application for temporary injunction, deny all that you can, deny the breaches being pleaded by the plaintiff, and reply whatever you want. There is one more interesting thing which is important both for the purpose of plaintiff as well as for defendant, that if the damage is of such nature that it can't be reversed, it is a good ground for injunction. But at the same time, if the damage is already done and now it can't be reversed, it could be a defense available. There is a big construction going on, 6 stories are built, and the plaintiff comes with a plea that I am owner and now my interest should be protected. By the time 6 stories are constructed or the building is complete, how could the situation be reversed? There could be plurality of interest that has been invested in the property. And as section 41 says, if the damage of undoing is likely to be greater than the damage caused, then better don't grant the injunction. So these are the cautions for plaintiff as well as defendant. And I think whatever I wanted to deliberate and restrict myself to around 60 minutes, I have done. If there are some questions, those who is going to lead the next session should better pass on the questions to me, because I have not been able to read the questions on the screen. Over to the... Yes, please go.
Absolutely, sir. So before starting up with this session, I must confess, this was a full of knowledge, a stupendous and an enriching session. We're so fortunate to hear you here, sir. However, there are a few questions from the attendees and the participants. With your kind permission, I shall proceed with the first question.
Yes.
First question is from Advocate Amol Joshi. He asks, sir, can you please throw a light on importance or scope of prayer? That is, any other relief may be granted in the interest of justice and fairness. What kind of relief the judge can grant in this case?
Okay, I'll put a simple illustration before you. Principle of ius generis, everybody knows. Things of that kind. Things of that kind and none else. Because see, that any other relief is to be read in the light of the basic thing, that no relief can be granted unless it is prayed. So any other relief could be alternate, the concept of coining the relief or concept of crafting the relief, but not what is not at all prayed, not a part of the plate at all. So this should be the principle, that any other relief is not a shield against anything that you want, or it is not a sort of a probing device. It's not a device to be put into heart to search out what are the defects and overcome those. It's not a dive to be put into the heart like angiographers do it. You have to first identify what the defect is. If the plaintiff does not know what he wants, how the defendant comes to know? That is what I'm saying. It is a very broader caution, because I have told you what is the adversarial principle. If you do not tell the defendant what do you want, the very principles of natural justice are violated. Therefore, according to me, fullest possible prayer is necessary. And what stopped you? What is order of 6 to 17 for? Apply it. See, I'll give you something very interesting. There are cases where suits are decreed, became final up to Supreme Court. And during execution, it is found that there is a defect in the decree. At that stage, suits are allowed to be amended. But even then, when you go for amendment, there is an application for amendment. There is notice to other side. So principles of natural justice are complied with. So anything that judge wants to give at last moment should not surprise the defendant. That should be the principle. At no cost, violation of principles of natural justice is permissible.
Absolutely, absolutely agreed and observed, sir. Second question is from Neha Jagtap. She asks, if suit is beyond limitation but for sufficient reasons and the same is pleaded in the plaint, is it necessary to file a separate delay condonation?
Okay, very interesting and very elementary question. exclusion of limitation applies to the plaintiff, condonation does not apply. I'll repeat it, very simple but requires repetition. Exclusion of limitation, where limitation stops running, applies to the suit, but concept of condonation does not apply. Since concept of condonation does not apply, separate application is not contemplated, but a statement contained in the plaint telling or narrating as to why limitation had stopped running has to be pleaded in very, very specific terms. It constitutes adequate foundation for notice to the defendant as to why the limitation has stopped running.
Precisely, sir. Precisely. So the next question is from Aarti Chilakwar. She asks, kindly explain the term interrogatories. How effective are they? How can a plaintiff show that defendant isn't submitting true information or he is suppressing it?
Okay, it's a matter of a full 1 hour session, but I appreciate the question. I congratulate the advocate who has put this question. And interrogatories is an excellent device of expediting the proceedings. I'll pass on my comment. There are enemies of CPC who say that civil procedure code is greatest impediment in adjudication, early adjudication, but their enmity based on not reading the CPC. If you go ahead with interrogatories, the stage of evidence is reduced to less than 1/4. I highly recommend it must be used. And you can do one thing, very specific recommendation for your institute. You have a webinar on interrogatories for invitees, those who make an application for those only. Let them go outside and become ambassador of interrogatories. No point in getting a session for 500 people and nobody follows it. Let there be only 5 persons. For your information, before 10 years, I had a full 3-hour session on interrogatories at Latur Bar Association. Discovery and interrogation, production of documents. I strongly recommend this must be done.
So,
CPC is eloquent, please do it.
yes, sir. So absolutely, we're so fortunate that you are showing this much interest for all attendees and participants. So we are absolutely fortunate for this. And we definitely has taken a note of this, that we shall be having a session on these topics from you, sir, and we shall be more enlightened with your guidance in a very nearer future, I must say. So if you permit me, I shall proceed with next question.
Yes, yes.
Next question is by Advocate Kiran Rajput. His question is, what precautions to be taken while drafting and pleading a counter claim?
Okay. See, precaution is everything that applies to plaintiff. But generally, I will mention what I have observed in my practice as a lawyer, because I did trial court work also for about 5-7 years. And I did drafting of all courts from Tahsildar to Supreme Court, even while I stopped working in trial court. Therefore, I am mentioning this. Normally, see what type of lawyers I have seen, I will tell you. I have seen the lawyer who would sit down with a paper and pen, client in front, asking him to tell whatever he wants to tell. Like an expert physician never stops the patient, permits him to speak. The reason is, clients are not trained to be witnesses. They are not formally trained to communicate what do they want. If you tell them from where did you come, he will say, I left Pune at 10 p.m. Then I took a bus for Satara. Then I changed the bus. And this is how he goes on telling. And you never know what important fact he will choose as important and what important fact he will forget as unimportant. Therefore, clients have to be permitted to explore whatever, because that is the only time in life that he has to tell something to you. Maybe you need more interviews, more conferences. Then another thing that I have done in my life, I have made the client to sit down with paper and pen, those who are literate, and write down their facts in sequence. I have been telling to lawyers one proverb which I have used, I can say coined by me, and recorded in one of my videos by Judicial Academy at Nagpur, that I don't like this, which I repeat. I never tutored the witness. Okay, first sentence, comma, not full stop. However, I never took an untrained witness to the court. What does it mean? Training of my witness begins from my drawing the plaint itself. I do not have to teach him and train him what he has to tell. I would not incorporate anything in the plaint which has not come from the mouth of the client. I would not tell him to tell any lie in the court, because in one of the workshops at Nagpur Law College, one boy stood up and asked me, sir, is it really possible to survive without making a false statement as a lawyer? खरं बोलून खरंच वकिली चालते का असं त्यांनी मला विचारलं. I told him that you have a person standing before you, don't worry. You can be shrewd, no issue, but you should never be untruthful. One thing I skipped, which I will mention, being truthful. One of the grounds on which injunction can be refused is that the court finds that the man is not worthy. Because during my such a long standing, I found that writ petition will be dismissed if there is no truthful statement made before the court. But then I was searching, where do I get that the plaint must contain truthful statement? That I found in verification. Once you say something is based on my knowledge, it is true. Then only you say that it is true on my statement. And if the judge finds that the party asking for injunction is not truthful, why should judge come to the help of a wrongdoer? A person who has no value for the truth. There lies the discretion of the judge. That is how you have to go to the truth and all these matters. So coming to the truth of the matter, you have to caution the judge, client, that don't come to me for filing a false case. There are many lawyers, and better I recommend you don't do it. So exploring the truth and giving little cautions to the client to be truthful, being accurate and being true are another thing. He gives you vague account. Train him to be truthful and train him to communicate the truth. If you do this, you are a very safe, you are a conscious lawyer. You stand up before the court. As one of the American lawyer has written a book, Gary Spence, on argument. He says that you have done this exercise, drawing the notes, preparing the maps, drawing pictures. When he says further, when you are standing before the court, not only your brain, but whole body comes to your help when you are arguing, conducting before the court. You are in one piece. You are not before the court in fragments. That is how you have to take instructions. Taking instructions is a skill. And as I mentioned to you, for this order 11, I shall give you some other lawyer. But for taking instructions, I have a booklet prepared on this. People don't want to be specific. Devoted. This is a job of commitment, a total commitment. This is not a part-time job. Though with the changed times, probably you need more sources for livelihood. But this is a job of devotion. You are doing a job support, a God's job. What is the definition of a good lawyer? You must have read somewhere. Do you know what is the definition of a good lawyer in Anglo-Saxon system? Anglo-Saxon system says that a good lawyer must be a good Christian. What is the concept? That doesn't mean that those who are not Christians, those can't practice. But this was grown in the Christian region, therefore good Christian. If you are a truthful man, you are a virtuous man, you can be a good lawyer. And how can a virtuous man be lazy? So being devoted, being committed is necessary for even drafting a counterclaim as for drafting a plaint. Okay, you can go to next question.
Humbly accepted, sir. Nothing to disagree with every single word of yours, sir. So I shall proceed with next question. This question is forwarded by Advocate Uday Yadav from Bita. He asks, what are those general mistakes in injunction application and its reply, and how can one avoid it?
Okay. One thing, common mistake, very common error is delegation of the job of drafting application to junior or to the typist. I have seen lawyers in those copy and paste in present time and in old days have multiple carbon copies. I have seen affidavits prepared on a carbon copy of a plaint. Leave 3 lines blank at the top and there write affidavit, write the name of the person. I state on oath as follows. and then that is the affidavit in support of application. What horrible thing. Never do this. If your client is poor, you have chosen to accept him. Neki aur push nahi chalegi.
Right,
No
sir.
compromise on good amount of effort. So draft affidavit separately, correct it meticulously, eliminate whatever was not required in the plaint, add those specific paragraphs. Why injunction? How the defendant is going to disturb your possession? What will happen if your disposition is done? See, at times what happens normally is a neighboring landowner who wants to encroach. So once he destroys the bund dividing two properties, it would create a grave thing. It would wash out your land. I have yet to come across a plaint where this is pleaded, that if the bund is destroyed, it will wash away my land. The whole fertile land will go. I am a farmer. I know what happens if the soil is washed out. But hardly any lawyer has gone to farm to find out how the soil is lost. The trees will collapse. It takes 30 years to grow the tree. And it touches the judge's heart. I told you the name of the author, Gary Spence. He tells that the man is cutting a tree and the person comes and opposes him. He says, I am earning wage. He says, you are killing two birds. You are killing their offsprings. What a nice argument. Can it not be advanced? Do the judges have mind and heart or not? Therefore, what would appeal to the mind of the judge has to be told to the judge in a very soft and novel manner, not in an artificial and in a dramatic manner.
True
So
that,
this is
sir.
a mistake that is commonly done. Never do it. And never arrogate yourself with knowledge that I have read the law and I know it. Read section 41 again and again. Read order 39, 1 and 2 again and again. I have seen that many things I had discovered after I had completed 40 years in the line after I read the provision for that purpose. For academic purpose, I read the provision and I discovered something new. I know one of our judges, retired judges, I would name him because I am talking good about him. Justice Bhutali used to say that even after becoming a judge, I read CPC every year once. That has to be done. So please go ahead with this.
Absolutely, sir. I guess all of our participants must have noted these words of yours, and everyone shall definitely practically go through this. So I shall just proceed with the last question of the session. This is forwarded by Advocate Sandeep Thorat. He asks, sir, kindly distinguish between amended and supplement pleadings in plain written statement and injunction application.
Okay. See, Order 6, Rule 17 permits the court to allow an amendment. An amendment is presumed to be dating back to the date of plaint. By amendment, if the party is absent, is very interesting. Once you move an application for amendment, defendant is absent, notice for application for amendment is served by summons. Amendment is either allowed or not allowed. But now we are talking of application for amendment being allowed. Amendment application is allowed. Amendment is carried on. Fresh summons is to be issued. All right. But take a case where in the pleading you write additional pleadings. No fresh summons is required. Because at the time of service of first summons, additional pleadings are already served. So amendment is a de novo infusion, implant in the suit. While it is not so in case of additional pleadings. So no further summons is required, no further issues would be framed. But amendment would add something new story and it attracts the principle of adversarial system for a fresh summons. I think I have tried to reply.
Absolutely, sir. Such a kind gesture from your side, sir. If anything went wrong, I apologized on my behalf and the training center's behalf. I want to proceed with the last session of...
Okay, before that, I will thank you for a peaceful audience and for this opportunity of inspiration. Thank you.
Thank you, sir. I shall ask Advocate Pramod Sutar, sir. I shall hand over the session to him for vote of thanks. Thank you, sir.
Thank you, Sheetal ma'am. I, Advocate Pramod Sutar, Chief Convener of Vasantrao Patil Lawyer Training Center, which is supported by Sangli Bar Association, express my sincere gratitude for your thoughtful and very interesting session, sir. I I know, sir, it's a very vast and complicated subject, but you clear it very minutely and express all the small necessities of drafting, pleading, and written statements, sir, and verification. Sir, your sentence that claimed is like a photograph will always remain in our minds, sir. Sir, we would like to see you again on this platform for your valuable guidance and experience, sir. Last, I also express my thanks to Sangli Bar Association who provide this platform for the said webinar, sir. Last but not least, all the participants who participate this webinar. Without their participation, this webinar could not be successful, sir. May I, Lord, with your kind permission, can I conclude the said webinar?
Yes.
Thank you, sir. We conclude the webinar. Thank you, everyone.